if you've got assets worth $1 million and a financial resource that's worth $1 million, then the court only has the power to divide up $1 million, not the $2 million total. It is important to work out which category it falls into. What a lot of parties trying to be clever used to do was to put assets into a trust, and that used to work quite frequently. The courts made it very clear that it has the power and the jurisdiction to look past the terms of a trust deed and to the real situation of a matter.
Welcome to Divorce Down Under, the Aussie way, where a regular guy like me, Matt, will help you navigate a fresh start following a divorce. After experiencing a divorce and going through all sorts of emotions, I hope to bring you the right tools and advice so you can set up a better life after divorce. Hear from experts and people like you who have lived it, sharing insights so you may find peace in a new beginning. Hi, Luke, how are you? Welcome to Divorce Down Under.
Hi, Matt. Happy Friday. It's a beautiful day here. Another beautiful day on the Sunshine Coast.
It is actually. It's been a bit weird, the weather. It's been super hot, then it's been raining with storms the last couple of days, and now it's sort of come out a little bit sunny, which is odd. So yeah.
yeah, it came good at the end of the week, which is great. Great to see.
It did. Before we get in the way, I thought I wanted to remind the viewers that this show is for general advice only. It doesn't take into consideration your personal situation. Therefore, it is not intended to be relied upon. And any financial or legal decision should really only occur after you've received tailored advice from a legal or professional like yourself, Luke. But I just thought I'd remind the viewers, as much as the information that you share is, on point and, I guess the right kind of information, it's really just broad in its speak.
That's right. And there is a danger, of course, as we know, and that's why disclaimers exist, that the advice given on a general basis may not particularly fit an individual's circumstances. So it is always prudent to go and get advice that takes into account individual circumstances, not just general advice.
Yeah, and I think and I appreciate you being on the show. It gives people a really good starting point and an understanding of sort of what steps to take next, and whether you kind of need legal representation. But I think it's always important to potentially, just to reach out and get legal representation, and they'll guide you on to the next steps of whether you don't or do want it anyway, which I think is the thing.
Yeah, precisely.
So, okay, we'll jump straight into it. We're going to talk about, you're going to explore more about, how to navigate property and divorce. And you will, the thinking is you're going to talk a bit more about the 4-step plan the courts expect when splitting property assets in divorce. But hold that thought, Luke. Before we get in the way, I'm going to ask you this every time you come on. Tell us something we don't know about you.
I used to be a Boy Scout.
There we go. I love it. So did I, actually. We got something in common.
Dib, dob, dob.
Yeah, I didn't know that about you.
That was a long time ago now, but a really great time in my life as well. I initially didn't really want to do the Scouts. My dad did it when he was a boy and said, you have to get into it. It's really great, and I was really reluctant, and I got in there and loved it. Fantastic, going camping and tying knots and using pocket knives and cutting things up, making fires.
Yeah.
It was really good.
The fire part got me when they said you get to make fires, and I'm like, when I'm a little boy with sticks and twigs making fires.
Your eyes light up.
Yeah. A bit of firebug when I was young. Love lighting the Barbie.
Yeah. Like all boys.
Yeah. Oh, that's great. I wasn't expecting that. Thanks for sharing that. Okay, let's dive into your first question. So I guess it can be property and assets is important in divorce because you want to make sure that they're equally split. And we've previously touched on in last episodes where, there's assets that aren't being hidden. But more specifically, what does it mean to have property assets when getting a divorce. Can you talk more broadly to that?
Yeah, sure. So, largely speaking, there's a whole bunch of different items that have been recognised at law um, that play a role in the first step of the four-step process that the courts adopt. So, if it doesn't fit within a category of asset or within the definition of an asset, then arguably it doesn't fall to be considered in dividing up the property pool of the parties that are separated. So it is important, I suppose, to identify early on in the piece whether an item is or is not an asset and fits within that category, because if it's not, an outcome might be produced which is worse for the party, worse for one of the parties anyway, because a particular item has been incorrectly, and um, the ordinary definition is adopted. So largely speaking, that's not too controversial. So things like real estate, vehicles, savings, shares, superannuation, although superannuation didn't historically fall within the category of assets. It was at one point in time considered to be a financial resource only. So it will either usually, if you fall short of meeting the definition of an asset, then it's typically, though not necessarily, going to be captured in this second category called a financial resource. And the significance of that is if you've got assets worth $1 million and a financial resource that's worth $1 million, then the parties who separate can only divide up, or the court only has the power to divide up $1 million, not the $2 million total. So it is important to work out which category it falls into. And then I suppose historically, what a lot of parties trying to be clever used to do was to put assets into a trust and then say, I don't have the power over this asset any longer. It's tucked away into a trust, and therefore it can't form part of the divisible property pool. And that used to work quite frequently. And the courts, though, have for some time now made it very, very clear that it has the power and the jurisdiction to look past the terms of a trust deed and look to the real situation of a matter. So, what was once probably a haven for a lot of clever people in family law proceedings is no longer available 9 times out of 10 for a lot of parties. So that's a very brief introduction to the distinction, I suppose, between an asset and a financial resource. And of course, once the court has identified all of the assets, then it's going to tally all of those up in a balance sheet, subtract the liabilities, and then that's the 100% figure that gets divided between the parties.
Yeah. And there's a four-step process that the courts follow. That's correct?
Yeah, so that balance sheet that I was just talking about, that's the first step. So
Okay.
once the court has identified that, then it moves on to steps 2, 3, and 4. And I often tell clients that even though parties should attempt to, and most of them do, resolve without the need for a trial in the courts, the same principles apply. So if you're never stepping foot inside a court, the same principles ought to be applied in resolving your matter, because ultimately the fourth step, which is to make sure that the result arrived at is just and equitable, is the phrasing that the courts use, or fair in layman's terms. If that's not present, and the parties do reach an agreement out of court, and then seek to formalise that in a court order, the court may very well reject that. So the same principles ought to apply in resolving it out of court. And so we talked about step one, that's just creating that balance sheet. Step 2 is to work out what the contributions are from each of the parties, and that's a pretty broad concept. It includes financial contributions, non-financial contributions. So if a party has applied their special skills, it includes parenting and homemaker contributions, and of all of those that we just talked about, it also includes direct and indirect as well. So it could be the case that there's an indirect financial contribution from a family member. One of the spouses may have had a parent who has helped them out significantly financially during the relationship. So that indirect financial contribution is going to be considered in the mix as well. And then and probably an important point to make as well, I think, for the viewers is that, and a lot of the men don't like to hear this, the courts have gone on at pains to make it abundantly clear that in a traditional style relationship where the man is out, he's the breadwinner, the woman stays at home and cares and raises the children, the courts will frequently make the point that those contributions that the woman has made in making caring for the children, caring for the home, are no less valuable than the man's contributions, um, and that's a dynamic situation, obviously, because societal roles are changing, and those roles are being reversed in some relationships as well. But the same principle applies no matter whether it's the man or the woman at home. That those contributions are, in the court's eyes, just as valuable as the breadwinner going out and earning the money.
Yeah.
So that's step 2. And then, and one point before we move on to step 3, one point that's worth making in relation to those contributions is the duration of the relationship. So, if parties get to about 20 years, it seems to be a bit of a, I say the magic number or thereabouts for the courts to say, we're not interested terribly in looking at contributions after a 20-year relationship. If the parties have been together for 20 plus years, the forensic exercise that the court would be required to undertake to disentangle all of the contributions and weight all of them would be just immense. The courts would be there for weeks, just hearing about every itemized contribution that each party has made during the relationship to the acquisition, improvement, or maintenance of an asset.
Yeah.
And so they generally say, okay, well, if you've been together for 20 plus years or thereabouts, we're going to say, and this is not entirely correct at law for me to say this, but it's a generalized way of viewing things. But there is 9 times out of 10, there is a no adjustment for either party on the basis that one has contributed more than the other. So the court's largely disinterested. So what I often say to clients, unless there's some really outstanding feature in the factual matrix of their case, I don't want to spend too much time drilling into the contributions over a 20-year relationship, because neither party's likely to get an adjustment either way, or if they do, it'd be very, very minor. And then that third step is to look at the future / other factors, and that's in a very simplified way. It's a bit of crystal ball gazing to look at the future to see how each of the parties is going to fare financially moving forward. And if one party's earning or got a greater income earning capacity than the other, then the financially weaker party may well get an adjustment in their favour to account for that disparity in income earning capacity. And then, there's other things as well, like, who has the primary care of the children of the relationship, and a raft of other things. But the main one, most of the time, or main two, are income earning capacity and care for the children moving forward.
That makes sense, especially if someone's not working and they're looking after the house, they're looking after the kids, and the other person is at work, building their career, becoming very successful. And that's because of off the back of that other person. They've allowed that person to be able to do that. So I'm assuming that's why they take into the considerations of some of the things you talked about.
Yeah, exactly right. And I often say to my wife Amanda that the I wouldn't be able to do what I do with running a business if it wasn't for her efforts in taking care of the home and the children that we've
Yeah,
got.
yeah,
Mm.
yeah. It makes sense. Step four. What was that?
So step four is really just to say, following the first three steps, if the result arrived at is not what the court considers to be just and equitable, it has the discretion to adjust that outcome even further. And that goes to prove the point that there's a very broad discretion that's given to the courts in determining the split of assets between parties. And it's for that reason, in my view, that parties should resolve matters themselves. If they're resolving it themselves, they have control over the situation, the outcome. It's an outcome that they've agreed upon. If you're going off to court, you just don't know what the outcome is going to be. You're effectively putting the control of the outcome into the hands of the courts, and the legislation has given, obviously, some factors to guide the courts into what it must or should consider in making a decision to split up the assets and liabilities, but it doesn't attribute any particular significance to one over the other, or apportion a weighting to the relevance of each of those factors. So it's left to the court. The judicial officer has a broad discretion to say, okay, I think this particular fact or circumstances is more important than the next one. And that's why lawyers often talk in terms of ranges when they say, okay, if you did go to court, I think that the outcome might be between X and Y for you, and in terms of percentages of the split up. Um, and that's because it's not a science. It's not a mechanical process or a scientific process where you can, or a mathematical process where you can properly identify exactly what the outcome is going to be. There's a huge human component, a subjective component,
Yeah.
and that's why I often say it's more like an art form than a mathematical process.
And that's why I've always said you don't really want to go to court. And I don't say that because the court is bad in any way. I think I would not like my decisions, to be made by the courts. But in saying that, you don't always have that choice. There are instances where you do have to go to court, which I completely understand that as well. Would you agree?
Yeah, sometimes, well, oftentimes, I think that a party has two choices. If there's no agreement, they either capitulate and surrender to the other person's point of view, or they insist on pushing forward. And it's not an easy situation to find yourself in. And the reason is, if you can't, if you've got two people, or one of them being unreasonable, and neither is giving an inch, or perhaps you've got someone who's being entirely reasonable, but the other person's scorned for some reason. There's
Mm,
something happened in the relationship, and there's a bit of resentment there, and they're just refusing to give any ground. Um, what what will often happen is that the court proceedings commence, and then there's this huge emotional and financial toll that gets waged because the other person's refusing to give an inch, and you'd like to think that, okay, well, if this person's being unreasonable, the courts will intervene and then fix this,
yeah.
and they do. But the problem is, in a property settlement matter, it's such a long, drawn out process. It typically at least 12 months or longer from the time that the documents are first filed until the judge hears the matter on a final basis. So you can imagine the emotional and financial costs that get incurred during that time because a party's digging their heels in. And so oftentimes what happens is that you go off to a mediation conference, and you choose a mediator who's going to hopefully get through to that person who's digging their heels in, and get them to see sense,
Mm.
and resolve the matter with giving up a little bit of ground so that there's compromise on both sides. And failing that, if it does go through to a full final hearing, and the reasonable person in that situation has the strength and the financial resources to take it that far, they'll get a decision which is better than the offer that's been presented along the way through by the unreasonable person. And um, and and there's also a power invested in the court to make orders that the unreasonable party pay some of the legal costs incurred by the reasonable party in the situation.
Yeah,
So there are some punishments there, but oftentimes I think that it's a war of attrition, I say.
yeah.
Be,
And
be, be,
I was going to say, I think it's really important to actually seek, the services and advice from someone like yourself. And it's why I like getting you on the show. It's because you're very fair in the way you deal with both parties. You want an equitable outcome, and it should be that way for every single party. And I think
mm.
by approaching someone like you, they have that years of experience, that they've gone through so many different situations that they can explain that very quickly. And I think in the scheme of things, it doesn't cost much at all to be hiring a lawyer. When you think about you're dealing in $1 million plus properties, that's a lot of money. That's a lot of assets that you're going to need to divide, and you want to make sure you get it right, because it's very difficult. I can't remember the saying you used to have, but it's very difficult to reopen the case after it's been closed by the courts. Is that'd be correct, wouldn't it?
Yeah, they're very only limited grounds that the court's got available to it. If a party comes back later on and seeks to set aside or vary a previously made order or agreement,
Yeah,
and it's usually confined to serious situations of fraud or undue influence or unconscionability. Circumstances where a party may have hidden a significant asset.
yeah.
So there are very limited grounds. So you do want to make sure that you get it right the first time around.
Yeah. And the good thing is, with if you do own property, there's new services around where you can actually get legal funding through a line of credit that will allow you to actually get access. Let's say you had $1 million property, let's say you're 50% each. One person can draw down on that property. Let's say they get approved for 100,000. They can use that, not all of it, but obviously they have the capacity to use that as a line of credit to pay for services like any legal expenses. So people think they got no money, they don't have any cash, but they don't realize that they can actually get a line of credit, and they don't take into your income, any of that sort of stuff. It's not how they decide the actual whether or not you're eligible. So there are ways for people to get access to lawyers when they think they don't as well, and property is one way to do that.
Yeah, it's not like a loan where you have to prove your income earning capacity, that and these are specific. The organisations that you're talking about specifically assist people who don't have the cash available to service a debt, but they know the lenders know that the parties are going through a property settlement, and they will at the end of the matter have some cash available to pay the lender back at that point in time. And becoming an increasingly competitive space. So you're getting some pretty decent rates as well on the funds. It's not like, I remember when I first started practicing law, litigation funders we used to call them sharks, because they were just the interest rates were so exorbitant in those days. But it's because it's such a competitive space these days. The rates have come right down, which is great to see for people going through the situation and don't have the funds available right now.
Yeah, and it gives the average, or the person that's, I guess, more in that vulnerable sort of position, in the sense that the other partner's gone, and worked all their life, and now they've got the income when you split, and you don't have the income, and you sort of left there, with no income. But there is a way to get access to that, and that's through the line of credit, and that's why I like some of these new businesses that come about, they're supporting people in those sort of vulnerable positions that could never really get access to any kind of law proceedings.
Yeah, it is good. It is good. I do like to see that there's a bit more of a level playing field when, um, and look, there are other mechanisms as well. Um, there are a couple of different cases that the courts have made decisions on. And as a result of those court decisions, that there's a principle at law to say that if a financially weaker party in the situation can't afford to pay for their legal fees, they can apply to the court for an order to access funds that are jointly held funds that without an order of the court, the other party's not going to consent to them using. So you can apply for what's called a Barrow order or a Hogan order, where that financially weaker party can tap into funds, joint funds that are sitting there, so that they can level the playing field as well.
It actually would be a good topic to talk about more in the future, because since you mentioned that, you obviously got legal aid, and then in regards to if there are any cases around domestic violence, there's Section 102 NA, and that gives you access to funding as well related to child support and similar. So we could maybe touch on that in the future, Luke.
Yeah, that's another topic to expand upon for the viewers for sure.
Yeah. I think we've got everything. Did you have anything else you wanted to finish on?
I suppose just to recap, what the viewers, if there are viewers out there who are going through this situation, I suppose a good starting place for them is really to work out in a bit of a balance sheet, even before you go to see a lawyer, if possible, what all of the property is, the assets and the liabilities. The lawyer will want to know how long the relationship was, whether there are any children, whether either party came into the relationship with any significant assets, and what the financial needs will be of each of the parties in the future, and also whether there's been any agreements as well that have taken place post-separation between the spouse parties. But it's just about preparation, I think. The more prepared, getting back to the scouts, be prepared. If you can go into a legal consultation as prepared as possible by doing some of those bits and pieces, you're starting off on the right foot.
Like you build a fire.
Yeah.
Big.
The puns are coming thick and fast today.
But you shared a PDF that your team had written too on actually property assets and the 4 steps process. If you're okay, Luke, we can share that in the comments section of the video.
Yeah, great idea. Yep, that'll be a great resource.
Yeah, because it was a 20+ page, I think, PDF that you put together. So we'll share that, and they can read it at their leisure.
Yeah, and I think that document from memory captures a lot of the information that we've spoken about today, and probably has a bit more in there as well.
Yeah, no, excellent. Again, thanks, Luke. I hope to see you again on the show, and I wish you the best of the week.
Yeah, thanks, Matt. Have a great weekend.
Thanks, Luke. Cheers. Bye.
Cheers.
Thank you for listening to Divorce Down Under, the Aussie way, helping you navigate a fresh start after divorce. We hope you enjoyed this episode. If you did, please leave a review from wherever you are watching or listening, and don't forget to share this with your friends. Also, let us know what you want to hear in future episodes. See you next time for a new episode of Divorce Down Under.